Okay, so we're going to call this meeting to order of the SLA Policy Review Committee. Steve Ballinger.
Here.
Michael Bavaria here. Mike Meltzer here. Here. Okay. Megan Joy is absent and Sandy Clay. Sandy actually let me know that she will not be able to attend. She's traveling for work, and Megan said she would be a few minutes late. Okay, so as we've been in our regular committee meetings, we've been discussing our policies and our guidelines and everything else for a while. We've been saying we needed to take a look at them. So this is going to be the first step in reviewing our current guidelines and SLA policies. We then will make a recommendation eventually to the full board on what we need to update in terms of our guidance. So my goal for tonight was that we would just basically get a grip or get a handle on what our current guidance and policies around the SLA information, procedures, applicant information, etc. So, that's why as we heard from the committee meetings, we hired a paralegal that's helping us out. She kind of went through, pulled out some conflicting information and some things that is duplicated, some things that is outdated. So it's just going to be, so that's what this legal packet is some of the things that she's kind of reviewed and sent over to us.
What do you watch to see if anyone else is getting it? I don't think anyone is now, just keep an eye on it.
So that being said, that's what the staple packet is. The second little individual is an advisory that goes along with something. So my goal tonight isn't to make any changes or recommendations necessarily tonight. There may be a few things that we say, this is definitely, this is very simple, we're going to change this, or this needs to be changed to include open dining as opposed to the temporary open restaurants program, etc. And then we'll take, after our initial review and in the comments we have tonight, compile that into another step of I don't want to say a final, but another draft document. We will then review that at a later meeting. I think we do have one scheduled for May 21st. I think it's May 21st.
Is that board or that's our next?
No, it'll be a separate. We'll again do it as a separate committee. And my goal tonight, I don't think we can spend more than an hour. I don't think it's going to be a long.
I won't be here on the conference.
We won't be here for May 21st. Well, it's stuff we can also.
Can you do on Zoom?
I could probably hop on Zoom.
Because these are on Zoom.
Yeah.
You actually don't get a 10 minutes credit on Zoom because of open meeting. But you're in, it will be important.
And in this case, it's more informational and having your recording it. So.
Okay.
Do you want to do this share screen?
Yeah. You have this in one document?
This one, no, this is one document. This is what she sent. I just printed out.
Oh, you printed out the one document.
This is what she sent to us.
The later.
It was no better than I do. But I know it. Like not like a lawyer.
Some of this we can just change things, some things just because they're wrong, they were right at one time. We're going to share screen so you guys will be able to see that.
They're exempt.
I think we don't actually have to deal with that at all because the board already voted on that.
Yeah. We can just review that and make sure that it's all that we voted on that last year. So.
Stuff that was last year.
I think so.
Well, it's pretty. It's pretty full of day. We just changed it. We changed one word. Where it has number of tables and chairs and stipulations, we no more instead of. It's in your.
I thought that I mean, it's trying to find my document. It has these all. I have them separately.
No, she said it's 3 attachments.
Yeah.
This is 1 of 3 attachments.
One was her invoice.
Yeah, one was her invoice. One was, I don't know what one was, and one was this. So,
Just give me 1 second. I'm gonna put on the screen, what I'm trying to do. Well, just in a different, when I opened it, it's in a different order. Okay, I'm gonna share my screen with this document.
Pat, I should tell you, we're not deciding anything tonight, it's just reviewing old stuff. Trying to save you a meeting. It's for, right again. Perplexed.
No, I was just looking. I think I got. Screening. Okay, everyone, so. Now, on screen.
There you go. It's a different order, that's all.
Yeah.
I don't know if you want to start with that page.
Yeah, I think I'll start with the lower, the first cover page.
The guidance to liquor license.
Yeah.
Which we,
I'm just trying to make it easy, but.
There we go.
Better?
Yeah.
Okay.
Okay, so everyone, you see on the screen, this is our guidance to liquor license applicants. This is something that we use ourselves on the board, but this is also what, when someone reaches out, this is what Susan uses to give the applicant the information they need and know what to expect if they're submitting an application and things that they should be looking out for, things that we are looking out for as well. So, and there's a few things comment notated on here that Anne Marie is the paragraph we had, pull a few things. So first thing she noted was that, and this was something that Susan and I went over a few weeks with her, where it says portions of East Village, especially Avenue A and St. Mark's Place. In this case, things have changed a little bit, so it would be Avenue A, Avenue B, and Avenue C are the portions of East Village. And then, and the upper lower east side area out is Street, and then, but the quality of life complaints and all others will consider residential street and those with commercial overlays. Including. Yeah, actually, we're just taking out including and we're saying and those with commercial overlays will be considered differently with commercial ag.
so we're basically adding 2 avenues.
And just clarifying the language of the second phrase. And that's, again, we can make more changes to this later, but this is just our initial path of things that stand out. Second, under the third or fourth bullet, the third bullet is fine, we're not really changing that. The fourth bullet, we are addressing some things because expansion of existing space conforming locations in residential areas and multi-client method of operation. Under the new city of yes, that has changed. So we no longer have grandfathered commercial uses on residential streets. It used to be a use was grandfathered on a residential street, in a residential zone. And it could not expand that use, it could not,
I don't know if they can expand, actually, it's something to.
confirm.
So what has changed is it used to be, it became vacant for 2 years, to revert to residential. That's no longer true, but we'll have to check about
That's the
expanding.
expansion, okay. So we'll confirm with that with the city of yes. And then R and C ones that are scheduled.
That's still true.
That's still true. Afterwards, it's on the private property, that is not necessarily true. R and C ones are scheduled on private property.
That's still true.
So true.
I thought aren't they allowed? For example, if their storefront is set back, they're allowed to use that space for dining table without getting sidewalk.
But this isn't about, this is about schedule.
Then it says, well, it says, comma outdoor use on private property.
Private property, outdoor dining has nothing to do with private. Outdoor dining is dining.
But some of those places on the side of the street that have a setback,
That's St. Mark's.
like on St. Mark and even on 4th Street. Aren't they allowed to use that space without a sidewalk and make a permit?
Well, they didn't used to be, so that's another, so
Yeah.
that's something really good. So
Yeah.
that's something to check.
That's what we need to find out.
Can we use private property in residential
Without a sidewalk and a permit,
with
or
or?
with or without, yeah, period.
Yeah, so that's something to find out, but everything else is still scheduled performances, ticketed events.
Megan, just to catch you up.
Yeah.
We're just kind of, our goal for tonight is just to review our existing guidance and requirements for the SLA policy. We're gonna go over a few things that are kind of obvious changes that need to be updated to address the current changes that we can deal with restaurants. And then we're gonna kind of compile all that and then come back at a later date to actually look at what we want to make, any other changes other than just making things consistent.
Okay.
Or, you know, what the zone was, if, I got residential, like residential street, like St. Mark's, private property, are they allowed to use that for?
In the property.
I think they have them on 12th Street too, but they have that patio, they are all using it and they all.
But I don't know if it's legal, St. Mark's always used for, it, but it's always illegal.
I feel, yeah,
Like what used to be Cafe Lane, that,
Yeah, it was always illegal.
I mean, you know, right, that's the space that we're talking about.
Yeah, I just don't know because City of Yes changed things. So I guess that's worth checking.
but we haven't looked into it.
Yeah, so we're also writing down things that doesn't check.
Right.
Yeah, so the first page that I think we just finished, that's currently as it stands, what our guidance is to liquor license applicant.
We haven't made any changes there.
Other than under the second or the first bullet point. The only thing clarified is such as portions of, and one thing, what we're looking at, this is a packet, we had a paralegal that we've hired to go through and review all of our information. And pull out some inconsistencies or things that are like, you know, in conflict with the other. So she pointed out those things, and then Susan and I had a few comments for her that she was forward. So this, the first bullet point. Under portions of each village, it used to say especially Avenue A and Marks, or adding Avenue A and Avenue B and Avenue C.
And just sort of FYI, she actually works for a really good legal firm that represents SLA applicants, so she really knows us.
So she had experience with it
Yeah.
in the past as well.
Right.
And then the second bullet, the second thing we changed was kind of clarifying the language and saying residential street including, we're taking out including, saying residential street and those with commercial overlays.
Okay.
Okay, so then the second page is what's up on the screen now. So this, I think this is something, this is the administrative approval process. I think this is something we can look at later to make any changes. The one thing that has been tossed around, we can just to kind of stick in your back pocket to think about is, right now. You have the requirement that it be at least a year. I think there's been discussion of making that a 2-year requirement simply because if we make it, and this is my opinion, and everyone agree to however. The 1-year requirement, they get their license, it takes them a month or 2 to ramp up. And say they open in August. They don't really ramp up till September, October, so they miss the summer. They come back next July and they're applying on their 11th month for their upgrade. We have to really see them operate a full year, because those first 2 months don't really count. I think personally, it should be a bare minimum of 18 months, if not 2 years. The other thing that I would, in my opinion, is the administrative approval process, I don't think was ever intended to be a stepping stone to a full liquor license, or a way to get in without going through committee and then come back in a little time. I don't think that was ever the way it was intended.
Yeah.
I think what it was intended for was businesses that actually are legitimate restaurants that intend on closing at 11 or 12 o'clock every night and only one beer. And it's a way for them to get through without having to go through the additional for the full license. So what's happening, what I've been seeing in the past few years is people are coming in for they're coming in administrative approval. And then on the 11th month, they're sending in their application to upgrade. And to me, I would rather see them come in the beginning and say, you know. Because their business plan is either we eventually want to have full liquor, or we want to just do beer and wine. And if they're coming in and just saying we're doing beer and wine, but then we're gonna change the liquor, I would rather them come in and just say from the beginning, we want to have full liquor and we'll close at 12, but we want full liquor or something else.
And then we would hear that.
And then we would hear it at the committee. But I feel like that, to me, that's a little bit better than, or I don't know, it's not better or worse, that's the wrong terms, but I would rather them just be upfront from the beginning.
So one of the reasons for this was to address complaints, it's like night noise complaints, and sort of give a carrot to those who are having businesses that can cause more of the noise. Also, to not have to go through the whole committee thing, if it's not really impacting the community in some places, it feels like the community. But as Quinn says, it's not being used to say, okay, I'm gonna have this business. They are now getting on the agenda after 11 months of operations, and by the time they're on the committee, that is not the whole point of it. So I think it should be at least 2 years, because really, that's not the point of this administrative approval. Administrative approval is for a different kind of business. I'm also going to make a suggestion to consider. Part of this is to address complaints. And I do not believe that the difference between beer, wine, and full liquor is the issue of late night noise complaints. I think it's hours. And I feel like restaurants that, you know, when we first started this, dealing with this committee, restaurants had beer, wine. That's not true anymore. Everybody has cocktails. And I would suggest that a real restaurant that serves cocktails and closes at midnight should be eligible for administrative approval if they're using, but not to use this.
So I didn't approve liquor, but 12. No other.
That's my suggestion, because people use beer, wine because beer, wine are less complaints, and they always say prove yourself. It's really not true. It's just not true. You can have the beer
I would
bar.
agree.
What?
I would agree with this is saying you could have the same problems with.
And
vodka
it's a standard, what we should have included, I don't think we have in here, is the actual administrative steps, do we?
No, we don't.
But we can take a look at those for the next meeting, but it's closed at 12, no live music,
It has to be food based.
yes, food based,
12 all nights?
or like
Yeah.
12 all night.
Yes.
So it's like, right now, our administrative tips are closed at 12 all night, no live music, no promoted events, all that, those tips. Is there anything else, no burgers?
It's basically,
Yeah.
it does allow out the.
It does, yeah,
So the definition of 1 year operation, that means when you first open the doors, not when.
that's technically what it would be.
But what they're doing
Not-
now is 11 months getting them together, 11 months of operating.
Of operating, not like I submitted. my-
It's not, no, we've always counted not from when you take the liquor license, because that can be, as you know, several months, years. We've counted it, you at least have to be open and operating for a year. But what they are doing is they're coming in, they're applying on their 11th month because they know that we'll hear them on the 12th month, they've been open for a full year.
And I think the kind of well-funded applicants can even work that into their budget, they're like, are gonna take the hit for a year.
Yeah.
And, you know, so it's. You know, you could think like, oh, we can handle this better, and then, so I think if we made it longer, like 2 years. That would, you know, prevent those people from doing that.
And I think what also, and Susan and I have gone back and forth about adding liquor, I'm not totally against it, or adding full liquor, I'm not totally against it. I know it doesn't make a difference, but what it does is, then, even if it's only till 12, we added full liquor with not really coming to us, and they close after a year, someone else can come in as a sale of assets,
But as long as they're closing by 12.
but they
This
can
is-
still close
Yeah,
at 12.
this is where I think we fall off the rails a little bit, is because you can't have one, you can't have, one rule without the other one, you can't follow one procedure without the other one, right?
Yes.
So if you say, I guess we'll allow the administrative approval for liquor to midnight, that means that place is really designated a restaurant that's gonna close at midnight, and when they come, when
That's-
they sell and they come back, it's, and this person's like, oh, I'm for liquor, and now I wanna open, you know, 1 or 2, it's just like.
This is
no,
what comes
you're
up. This is
buying
where-
a restaurant.
That's
and
exactly
probably
where I
paid
go.
less,
So that
But-
would be part of it.
closing.
That
That's,
would be part
that's
of it.
exactly where I was going.
Yeah.
If we were to do that and add full liquor to that and approval, we need, and I'm just, this is gonna be my very initial thought of our language, but it'd be something like. You know,
Notice
In-
that in event of a
in the
sale,
event of
each
sale,
businesses will be kept to the same numbers.
yeah, or something, and, you know, any requests for upgrades. Well, like they're already full liquor, but any request for extension of hours for method of operation will be considered, will be evaluated more strict, you know. I think we need it, and we need to make a note of those in the minutes or in the resolution. So that when they come to us in the future, we can say, they were strictly approved as a restaurant. Now, you know, that place closed, and that place is coming in, and they want to be a bar, but we can't just say, oh, they have full liquor, we can let them. We need to be more, because, and we did it this last month, we approved 3 unlicensed locations with full liquor.
Wow.
One.
One with one line of beer, but they actually, the next day, you know, they're coming for full liquor. They
That
just,
one's going back now?
yes, because of the temple, they're determining if it's a legitimate.
So then. Does that, so, you know, you loosen the reins on one end and you gotta tighten the reins on the
Yes.
other end, but do you? For those licenses that are coming before you that are not administratively approved. Well, I guess why would they come before us if they want to play the phone anyway?
Well, so what we do is when we get an application that gets the 30-day notices. And then they, every year one, he then contacts them and say, you may be eligible for administrative approval, will you be notified midnight?
Mhm.
So he, you know, that's something he does.
Yeah, because if they were just a regular applicant and they didn't qualify for administrative approval, but we gave them public lot closing,
That's it, I don't,
is that different?
yes,
Then that applicant can come back.
Can they come back
Yes.
Right.
for later?
because they weren't coming through the administrative approval.
Exactly.
I agree with this, I just think we need to be really transparent.
We do.
with this.
I agree, and we need to be very clear.
Landlords need to know it, lawyers need to know it, applicants need to know. it.
And we would have to track this, you know, like.
Yeah.
You know.
Well, and that's, it would have to be, what would be, and this is one thing that we wanna talk about as a committee. One thing that we've slipped on that used to happen more so than it has, in our resolutions. We should be looking back at the previous, what was previously approved for that space, and we should then be comparing it. With what we're approving for the new applicant. If the previous licensed space, we should be looking at what was approved in the past, just so that we know. And I know it's not always easy to access, and we can do a little training class and all that stuff
Please.
for it, and
Please.
figure out a way to get that, so that it's all in one place, that everyone can access it, but, yeah.
Why don't we make that part of our assignments? If once we figure out, cause
Yes.
like, it's.
Picking up the old steps.
Just
Yeah.
that.
And so you
We
can,
can-
you can find the opposite. We are now posting all stipulations on the
So
website.
recent for the last.
But we just started doing that. What is on the website right now is the resolution, which actually has all the steps.
Yeah.
It doesn't have the step form, but it has it numbered, so it actually has what the steps are. And the questionnaire is still on. The questionnaire becomes irrelevant because that's
It
their
was
plan
one.
when they come to us. By the time they leave us, the plans are different.
And at some point. Not in this process, but I do wanna, whether we have a meeting or I meet with you individually, just to go over what we are including in the resolution, because I think there are some things we probably need to beef up a little bit more. And it hasn't been an issue for us, but it could down the road, so.
But I think, if you have a saturated area and new business comes in, it is legitimate to say it shouldn't have a greater impact than the previous.
Yes, I don't think any of it. Laura had her hand up.
So just something to offer for consideration is that if you want to administratively approve full liquor licenses, you are basically excluding the public from the opportunity for a public hearing. I can't
Oh,
imagine.
actually, wait, that's a good question.
Yeah,
If. If we do an administrative approval process. Full liquor, would still have to go over a 500-foot hearing, won't it?
Yes, but it would. That's the community being successful.
Yes, I know it.
Once the community board
Has approved it.
approves a full liquor license, are slim to none. So.
That's a good point.
Referring your decision.
Very-
That's, I agree with you, like. About the establishments that cause problems.
Well,
And I feel like the administrative burden, it's already very, very different, right? To do a license. Especially in.
Well, but-
economic
but-
climate.
but I will say our current policy is, and we very rarely do this, but if there's something on the administrative approval list. And residents have a problem, they can come to her before
Or change to her.
and change the herd committee.
Right.
I don't know that, as,
It's just, again, it's putting a lot on the
is.
residents and on organizations like mine to notice something coming up and.
But if I could say, realistically, the SLA is never gonna turn down a business that closes at midnight. So,
Right.
it's the same thing with beer and wine. I had on occasion, people say to me, oh, I want that at committee, and I said, yes, we can do that, but what do we ask for? We're gonna close at 11. What better stipulations can you get?
Right,
And if someone is a restaurant, not a bar, a restaurant applying for full liquor to close at midnight. Granted, some people might want to oppose them and they will have the ability to put that on.
I just feel like we just did one with,
Hot house, hot stuff.
House of Pasta was approved for full liquor.
Oh, that's right, it wasn't an admin, it was, it gets me.
Was, Fish Market.
What?
Fish market.
On Avenue A.
And so what happened? Did we?
We
It was
denied it,
denied in the SLA.
and the SLA denied.
And then they were closing
You
it.
put in the school, you put in the church. The
Oh, but that's
That was,
different.
yes,
But
that was
that's a
the-
whole different
Right.
thing. That's a technical thing.
Yeah.
And all you need to do is go to the SLA and say, this is the church. But that's something that happens once.
It's just an if it's on the agenda, as we've been doing, the full liquor is serious enough in the area. In particular, it's a serious enough step that I think a lot of the community. Will object.
I agree.
I
think people will object. I think there's also an over. A large view of what difference does it make, what bang for your buck you're gonna get? And the amount of work that can be done here, to be honest.
get it.
No, I know you don't disagree.
I also wonder though. If we're approving. Sorry,
You know, then do I come back and say, okay, the new easy way in is I'm a restaurant that closes at midnight and now I go back in a year and I want to extend my
No,
hours.
because
They
you
should
wouldn't,
make it much stricter.
And can you legally hold that?
That's,
Yeah, it's always been, no one's ever challenged it. The only thing that's ever been challenged is that if some people won't sign, it says must come back, upgrade must come back and be approved by the board.
like stipulation number 11, it says, if they're going to the hearing one, it'll, and I think it said it in the
There's
guidance that.
never been an objection or a challenge at all.
I think a lot of restaurant owners who wanna close at 1, 2 on the weekends, be like, you know, I could probably go 12. I could probably get
And-
donated.
And
exactly,
maybe what we can do on the not murder committee is separate out the full liquor.
Yeah.
It gives the public an opportunity to talk on those.
Well,
No.
Yeah, they're.
it's the whole point of not murder committee.
It's already done.
But what I'm saying is if they do wanna poll them, we can just, which I don't think will
It's
happen.
very rare it happens.
Yeah, but
Right.
we could just seperate them, so it's really easy to see for residents, they don't have to go through them.
But I also, I also think in order to address, I get some of the issue, one thing we may. You know, the, I guess, guidance or our policy about it is that it can't be a location. That has been a problem location, or a problem operating. I don't think we currently have,
What
I don't-
defines that?
Pardon?
What defines that?
Yeah.
Complaint.
complaints or violations.
So the problem with the complaints is, and we actually just had, a restaurant, I won't say the name, that, was applying for outdoor dining, but it was a terrible problem for 4 years. We just had him come in and talk to us about how he's gonna change. I'm still losing my thought on it, but the issue is, you don't have proven complaints anymore because the police are instructed never to give summonses. And therefore, when a business says, I have no complaints, of course you have no complaints, because what most of the police will do is refer for mediation. So,
Well, can we,
I
can
mean, like,
we leave that up to, our, like, do we have to have such specific guidelines on that, or can we just feel, you know, a lot of neighbors have complained about, or neighbors have, you know, a bunch of neighbors have called and we don't think they should go through administrative.
you can do that because I'm gonna tell you, there are sometimes complaints like, I had an elected official call me once about a place that was a bar and I knew there was no problem. And it turned out that ex-girlfriend was making all these, it was a personal thing. That doesn't happen. It's a difference between proving or not proving. I've had ex-employees do things.
And it's not that you're gonna deny them, but it's that maybe they come to committee. and,
So that's fine. You
I
can
think-
say there's a lot of complaints. It's fine.
And we can wordsmith the language later, but I think we should have something, you know, under the administrative rule, this, you know, this does not apply to problem location or problem operator.
Yeah.
Maybe leave it at that, and if that can be vague enough.
And we could say, and we could even,
Because we're not denying them, all we're saying is they don't follow the administrative approval, they have to just come to committee.
Yeah, you could use it.
I'm saying.
Great, so then if Laura looked at the agenda or some other, so it was like, really, like, not that place has like major
Yeah.
back problems that can cause noise complaints for. Like, oh, we should probably get these people. in front of us, we can discuss this.
What about for brunch focus, because brunch focused restaurants, brunch focused restaurants.
You mean, focused restaurants?
I didn't say it.
Because there's a difference.
So how do you put that in, how do you put that in?
Well, no,
Well, no, you can't.
it's currently in our admin stipulations, and no unlimited drink special food.
Yeah, that is me, but that's,
That's what brings in crowds though, honestly, it's the unlimited,
Yeah,
it's the unlimited, it's the unlimited
Most of
services
it,
and stuff like that,
yeah.
that brings in really young, focused crowd.
but we currently have that in it, right?
yeah, but they just ignore it, they sign stipulations.
Yeah.
I'm just trying, it's brunch focus is different than no unlimited, there's a lot of places that are brunch focused and pretty loud and pretty raucous that are not, don't have the unlimited stuff. So I don't know how you put that.
Yeah, because we're not, the hours just don't really matter.
Yeah. Well, it's something to think about. I mean, we're not doing it tonight anyway,
Yeah,
so
but it's
it's
just-
something to think
Are
about.
there really that many places
No,
that
they
have
do not
burned?
like-
Yeah,
Yeah, you have like a stock department of a lot of like brunch complaints, it was noon and the noise wasn't said yet.
Because when mimosas are $12 each, usually they're not going back like that.
Yeah.
well, yeah, I mean, that's
True.
what?
$20.
Yeah, it's people that are using the real cheap stuff for the very young rocket.
Well, I know the chief.
Okay, so again, that was just, and this again is just. The additions that what we were looking at from September 22, that was when we changed.
You can make a stipulation, no J Row J to be served.
Okay, so on to the next page, which is. This was the resolution we had in January of last year, it was 23, so January 23, for the outdoor dining program. This, I think we just need to make some tweaks because now the program has actually been finalized and working. Got here for everyone up here. There we go. So we definitely obviously need to change the name from open restaurant to. Out with
Dining out.
dining out and
Invoice.
so we need to update that with the official name, which we have. It's highlighted on it, we have it highlighted there, so we'll make that change. And then. I think everything else on here is probably still consistent.
Can I just ask which areas of 14th Street are not residential at all?
Sorry.
No, 14th Street.
Oh, say that again.
It says such as some areas of 14th Street, I just don't.
There are,
Yeah, them, like,
I don't think all, I don't know that all the blocks all the way to D are resident are.
I would, the only area that's not would be to the west. They would be,
Between A and B two.
no, I mean, no, really, west. It would be
Like around lines or something.
right around.
So maybe
Like
that needs to be,
between diversity and. You know, need a square.
What about the Whole Foods stretch? Residential?
Yeah.
That's good, it's
Trader Joe's, oh, not, sorry, not Red Foods, I mean the Trader Joe's stretch.
That's what I meant.
Trader Stretch, yes, it's residential.
Okay,
so maybe we should just say, take out such as some areas.
Only that's super western.
So just say such as. Except that that's not really happening because.
In some believe 14th Street is. Well, not residential, I'm not talking about the area right near Union Square.
No, I think you're right. I think it is.
Yeah. And I mean, I guess in that. You know, there are people who still live on the valley.
So, I'll tell you what's really happening is that we send the stipulations out. So far, we've sent out like something like 140 and 70 people haven't signed. And so when we send them out, people are already signed, the people are must have signed, so everybody's signing. So when you do have, like we now have one place on Maui that's not signed, it's not fair to let them be open later, because the other places on the same block are closing at 10.
Yeah.
And we have a place on Houston Street now.
Same thing, it's like all their neighbors are working with the board, and closing at 10, and then you have one that's not closing at 10.
how are they getting approved for their hours?
They're not,
They're
they're
not.
just not signing the
They're not signing the
stipulations.
stipulations,
So then how did they get approved?
They're not.
they have to go to the SLA.
We're gonna go to the SLA. So what happens, one, just to inform everybody, when we send stipulations, so as we announced at the meeting last night. CDs 1, 2, and 3 had a meeting with the SLA chair about 2 weeks ago on our team. And spent most of the time talking about SLA, she wanted to understand our procedures, pretty much the three boards have the same procedures, because there's just too much work to not just administrate with. And they were, I would say, generally very sympathetic to our concerns and our procedures. So what happens when someone sends us a dining out package, we send them stipulations. They sign it, it's like half a page. They said it's basically close at 10. All patrons must be seated at tables and chairs, and you must follow guidelines such as no amplified stuff. So we get those stipulations, we approve their outdoor dining, which is irrelevant because the DOT doesn't really put up an approval. We take those very same stipulations, and when they apply to extend their license at the SLA, they don't have to do anything, it's the same stipulations. We send them to the SLA, the SLA will administratively approve them much more quickly. If they don't sign it, the SLA will not administratively sign it, we will be heard at committee, we will go up. None of this hasn't happened yet, the first one has not happened to go to the SLA.
I mean, it's kind of smart in them in a way because they know now within the rules that they can still operate with the conditional approval like Katie and serve.
They can't serve like conditional approval. They're, people are doing it illegally, they absolutely can. Don't do it, Megan.
No, I,
I think just, we're just met with
Clarify that.
we just met with Lily Pam. And the lawyers, if they ask their lawyers, the lawyers understand, if they don't like it, that the lawyers are telling people, don't serve, you cannot serve.
yeah, that's interesting. I think we got some misinformation
Oh,
from the
there's-
Hospitality Alliance.
Yes, they actually said that.
That's true, because, no, I'm not gonna go into that. I found some of it very confusing also, that sense, I don't see us later.
And that's why part of the reason they wanted to have, they requested the meeting, right? Didn't,
No,
we requested
the
that.
CB one asked me.
CV one, but that's part of the reason that, and most of the meeting was spent on the outdoor dining, and they said, there's a lot of confusion out there, and there's been a lot of misinformation going around.
I'm gonna say that farmers think that what they got.
And I'm gonna be honest, if somebody does not sign steps, which is one case so far, and I see them serving liquor, I'm documenting that and use when we go up there. So I know, I just happened to be in the bar and talking about it, and he mentioned that his lawyer said that you absolutely should not.
Get back to this, we eliminate these, the whole block, street name, either eliminate the idea, but I don't, I'm not gonna say for sure that like there's no such thing as a block in CB3. But maybe take those names out.
Or actually-
Flexibility, or just get rid of it.
Actually, maybe that lines therefore be resolved in locations that are strictly commercial and not residential, such as Thomas 14th Street, Ballard, and TV3 would consider outdoor dining hours later than 1 p.m. Should we just get rid of that?
I think we should be, I was like to say, it's not a level playing field. So the businesses that are all working with the community and working with the board are being at a disadvantage because someone's gonna say, oh, let's go over there, they're gonna be a little later.
I think you have some. We go later, there
We
we
have
have one or two.
We have not.
We haven't yet.
We-
Oh,
we're
it's,
talking about
yeah,
outdoor
with
dining.
the new outdoor dining curve.
We're only talking about the outdoor.
I agree with you.
We have not
I think,
any.
Yeah.
I think
yeah,
that
you
we,
can- that's one wrong. I don't see the upside of it.
and I actually don't know what it's accomplishing.
That's what I'm saying. What did it accomplish?
So like I say, it's just not fair to the businesses.
Yeah, so make note of these. Right, tomorrow. And actually, if we're striking that, we probably need to strike the whereas above it, which says subsection of CB three are strictly commercial and outdoor dining won't impact residents.
And where would you?
So that's what I mean, so maybe,
We're in agreement.
Yeah, we don't have.
we don't. I honestly don't think any area in CB3
Right.
is solely commercial.
I'm having a hard time picking one.
Even if there's a block that is.
But And it's usually at least underneath residential, like very rarely is it.
Right, exactly, yeah. That's what I was thinking.
I think, does anyone, anyone have any strong feelings about just striking those last two?
Seems.
I know, that's my thought. Yeah, he said it's kind of good to happen.
Oh, very good.
Yeah, I think the rest of the stuff I think is still applicable and makes sense. What we might want to do though. And Susan, maybe under the third whereas where we have the time the citywide tax notice for open restaurants September 21, number one. We either maybe want to remove that or update. So we have to kind of,
We can't, we're saying at the.
oh, at the time of the
Yes,
rest of
it's
September
not
21.
Those are non-conforming.
Yeah.
So we're talking about what's still on
Yeah.
residential side. There's a lot more now because there's no,
Because it's allowed.
because of.
Do you want to correct in the hospitality ones, it's like, it's very important that the SLA has not issued any public statement addressing the two questions above, which refer to serving.
That's, which is very confusing. And it's true, they've not issued a statement, but they also haven't issued any licenses or permits.
There was definitely another email, or maybe not from the Hospitality Alliance, that was like, yes. No, sir.
Well,
But anyway,
I wish.
It's cleared up. We spoke to the chair of the SLA.
We did, but
We spoke to the chair. Oh, you mean they?
I'm just saying-
Hospitality, they don't want to clear. I think it's part of a lot. This place. Because they're not happy with it.
yeah, I think that the SLA is so dysfunctional in how long they take to approve applications. They needed to have a plan for this, they needed to hire more people to handle all of this.
And
DOT, I mean, the fact that they thought they could sort of process thousands of applications and.
To be fair, this isn't their program, this is a city program that dumped this on us, community boards and SLA. You weren't at the meeting, so last night as part of my report, I actually talked about how now we're up to, under SLA committee, over 70 items every month. And they don't come before the committee, but they're all in the office. So DOT has now hired this whole separate division that deals with it. We don't have one anymore to process this.
Right.
Same thing happened to the SLA. No one's getting them any extra money to process all the stuff that the city has created.
they were just trying to get out of the backlog from COVID.
Right, I mean, there is,
Or just, I think they're barely crawling into that hole.
they're not.
So, yes, you're right. I would think it's important for businesses. We are very careful. When someone doesn't sign the steps, we are very careful to say, we want you to understand that you cannot serve. And that's what-
Your point.
Yes,
So actually, yeah, it might work. If we're eliminating the therefore clause, we would need to replace that, therefore we resolve.
Oh,
If we
There has to be,
eliminate the therefore, we might as well just eliminate.
yeah,
yeah, that's the conclusion. Figure of there.
well, I mean, there's two ways. One is to take out the whereas and just look for it. And have a series of different ones.
well, and this, actually, this is the follow, this is the resolution. We would have to either, we'd be making a new.
Regardless of it.
Yeah, no, I'm not, but we'd have to bring it back, but essentially, we would be, it would be a brand new resolution, so we wouldn't have to necessarily follow this.
No.
Yeah, you could just make a bullet point.
It would just be a, you know. Community board 3, that's a layout with guiding parameters. And maybe actually, it wouldn't even have to be in the whereas format, it could be just like you, the other one, where it would just
Just make
be
a bullet point.
overall, that's, yeah.
So best practices, most of it is taken or some of it from I think it was the hospitality plans, and we updated theirs since then. And I'm wondering if maybe particularly that security is a pretty technical thing, with requirements by the SLA, and that we should just eliminate it from ours because we shouldn't be interfering with the security because because of the SLA requirements.
Yeah.
Environments agree? Pardon?
You mean,
Like, the SLA is at one guard for every 75 people.
One guard for what?
Every 75 people, it's one guard.
Yeah, so what I'm saying is, it's their requirements, we shouldn't have
Yeah,
requirements.
okay,
Because people should just follow the SLA requirements.
we don't need to.
Yeah, so I think that's what, if it's. I mean, I think what we should say, and maybe this would address a lot of it is, you know. Even though it shouldn't need to be said, but, you know, following all SLA guidance, and in addition, are.
The SLA is very strict about.
No, I don't mean just for security, I mean in general, you know, we would say our best practices are, in addition to the SLA requirements. We are asking, you know, these are the. So we would say, like, the best practice for security is an SLA thing, so that wouldn't be us, so in addition to, that's what we require.
So under cloud
Yeah.
control, to take out security and say designate. Take out security and staff, because security means a specific thing.
License security, and a lot of times that comes up at our meetings. Where designated staff, but we not making it require security, so.
And that one had, the thing hospitality.
No, we all have it, or
What do you-
they don't. Megan found it too.
You found it too. The April 2nd. It doesn't, yeah.
Harley?
Oh, you found the first one, yeah,
Yeah.
she found the second, we would clarify it.
Okay.
Where was April 2nd? What did it
April
say?
2nd. It says, good news from SLA and alcohol.
It was modality lines?
And what does it say we can serve?
What email address? Info at?
Yeah, and for, and I see Alliance over. On April 2nd.
I don't have the April 2nd.
All right, let me just forward it.
Hold on, I'm sure I had it too.
I actually reported to the SLA and they're doing an inspection on it because. Person doesn't have a, that's not.
I have you, that's in here, so. But it.
Here, I have it. Oh, here, I have it, because I'd actually pulled it.
so if the SLA does one thing, the hospitality say, was saying, well, should we have to like, step in on this and like? talk
No,
to
the
them?
SLA
I think
Honey, that's-
that all burned a
Yes,
couple
so it
weeks
is.
ago.
Yeah.
It's just an agency, they don't tell them. It's their agency.
They're like, well,
See it to please.
When did Lovely say that?
so,
That cancer without until they're.
Here, it's up here, this is what they originally said.
People that have a conditional approval
Well, and it's interesting, they say,
can't apply.
in the meantime, SLA's implication is that restaurants involved currently served operating,
Implication.
yeah,
April 2nd.
yeah, that's the.
It says the implication, it doesn't say the law, a lot of it says the implication. Anyone that serves alcohol because there's an implication that it's okay is. Nothing here.
Yeah, see here, as valid for document as well. So. It's making it, again, making it sound like it is, but if you really read it, it's not.
What they're trying to do is get the inside.
Based on the fact that people are already doing it.
many people are.
Exactly, I see that, I can see the strategy that you're saying.
All of my local.
So that, I mean, what we're talking about right now.
Pictures of them.
Oh my God, it's literally a thing, you would have to look up to see whether they're person like.
No, no one's been
No one's.
Well-
And everyone's doing it.
So back to the best practice. We're security taking crowd control would be the first security on number one to staff or.
I mean, it's possible that they're beginning to. Certainly know.
I mean. All of those are all fine crowd control,
What are you looking
just
at?
at the best practices.
I would add something to noise, are we on, noise control?
Yeah.
I would add something about, the exhaust or HVAC units,
Yeah.
because
That's
everyone.
a common thing over here.
Yeah.
Like exhaust. ones.
And I mean, maybe we. Any,
You could just say that HVAC.
any invasion equipment or system.
Effectively,
Has to be maintained.
Or
so
should
that
it
it's not
was-
noisy.
Any outdoor HVAC equipment?
Yeah, I guess all the ones are complaints. It's a very common
If
complaint.
we hear it,
Yeah.
we hear it regular this meeting.
Mine just broke. 2-year-old just like started making a big noise out of one of my spots. Over the weekends. It's happened all the time. It's how.
Are they called condensing units?
That's a unit.
Specifiable.
Uh,
Outdoor
But
condenser units.
HVAC general.
Yeah. HVAC.
And where it says, I got something. So under neighborhood relations, B, instead of saying community board can provide contact, the community board website has contact information under community. It's- Or you can, or here's Laura's.
I think all the rest of it was fine.
So the next page is the letter that we send with the cabinet to pick up when we get ready for the meeting.
I think that is all.
Yeah.
That's the thing that would need to can be changed, it's all just.
Yeah, I think it's fine. Back of the next page is something.
This is something that. we're from SLA,
Yeah.
yes, so that. I think that would change.
For reference.
Yeah, we'll just keep it on our website.
So this, the next thing we're looking at, this is currently on the website. This number 11, which is the transfer information. I think we discussed just removing this completely because
Yes.
it's old, it may be not necessarily outdated. The SLA still does use the word transfer, but that's very confusing. As we know, it's not only the transfer. I think one thing that's been described, a better way to describe it is like a driver's license. You can't transfer your driver's license from someone, from you to someone else. You can have a driver's license and then, your driver's license ends, someone else has to get a new driver's license to drive the car. It's not like. Something you can just transfer.
Yeah.
Yes, we have sale of assets, but that's still different. The SLA can do sale of assets essentially like a new license.
But they're
I
like.
mean, that is a transfer, but.
It is a transfer.
But nobody understands.
But I think by putting the word transfer on our website, I think it confuses a lot of people.
Makes people think that they could just buy.
Yeah.
When you sell them.
People don't have to explain this to the general public.
So
Yeah.
we should definitely take this
So I
page
think
off.
we're gonna take this page out and there's another section where.
Well, but this whole page is SLA stuff.
Yeah.
The person on here. Has been there.
Carry rides.
But besides that, we don't know when they'll take their information. So if we have their information, it's not.
Yeah, that's good.
Okay, so now we get to dance.
So this has also caused a lot of confusion because,
This was pre-CDPS, so this is no longer, well, most of this is no longer true because it's pre-CDPS. There are still zoning
yeah,
requirements.
I think that's why, we're gonna keep this, but adding additional language at the bottom.
I think the important thing is that, yes, that SLA requires it. That's the most important thing.
So I don't know if we should include the information above, because it still is, we could take out the grandfather section. Actually, no, that should still technically apply. We talk about Webster Harbor, Club, et cetera.
I don't think we should. Those were exceptions and they're not really exceptions. When they were exceptions to the testing law, because they made some of them including it 100 years back. But now almost anyone in certain areas, most areas can get cancer.
But I think, we need to make it clear, this last section. That, the SLA requires things that have to be part of the method of operation.
Yeah.
So, I mean, I think we still need to say something about the first section, it's no longer obtain a license permit for dancing. And I think we can abbreviate the next 2 or 3 sentences into something.
I think we should get rid of all this technical stuff.
Dancing as a curricular activity.
Yeah,
Yes.
it is.
They are not in our situation.
They are.
Well, not on the stipulation form, it is on the questionnaire, but it's not,
Questionnaire, okay.
it's on the question,
Yeah, it's not in the
it's
state.
not on the sticks, it's on the questionnaire. Maybe that's something
Maybe we should be honest.
we maybe need to add that to the sticks.
In 2018, when I came to the committee. They added it to my steps, so it's on,
But it's not a checkoff.
No, that was an additional,
there's additional. But now it's like you don't have to sign off on it.
You have
No, I
to,
didn't.
Well,
No,
you have to say it's part of this.
to the SLA,
You have to tell us that you're gonna have dancing as part of your method of operation. And you have to tell the SLA you're gonna have
like it's
dancing.
on the 30-day notice in your
So
application.
you're the only legal place in Nobles Village with dancing.
It's like no dance.
Oh, it says no dancing?
Oh, gee, that's-
So everybody dances, we know that. But
How are you gonna enforce
I don't know why people don't. Put it. No one's saying, no one has said to this point, you can't have dancing, because it's never. You
Came
know,
up in 2018,
for you,
yes.
and you had dancing and people were.
I
But the law was different.
Yes,
The law was different, you can't, the deal.
the law, that was before the law would change.
So do I have to come back and?
Yes, because you're changing your method of operation.
And that's that's less for the DP, that's more for the SLA. Cause that, and
Well, it's for us.
Well, for us.
Not for the city.
not for the city. So I think we do, I think it's important we have this here, because a lot of people do think. That you can have dancing because it's the city legalized it, and again, it's not that you can't have it, it's have to be part of your method of operation for the city.
So. Do you think we should put these looks like?
Yes,
Well, it
I
is.
think it's important, I think we should.
We should. But we haven't been like denying anyone because it's in the questionnaire, and if anyone had ever said in the questionnaire dancing, then we would have just added it.
Yeah.
So it's not,
I think bar owners are scared to do it because of the old laws, where it's still got the old mentality, like. Can't say dancing, like,
Yeah.
it's bad word.
they'll think we just approved and also.
They think that we're gonna just.
We can do it without, we can do it with being legal, and no one's gonna do it.
So I'll take a stab at, at least cutting out, we'll have, I think we'll start with the, it's no longer necessary to obtain a license and cut out the technical stuff. And then,
Just have the method of operation of the business does not provide for dancing, the business must apply. Keep
Yeah.
that in, keep in the new stuff SLA requires it.
Yeah.
The bottom stuff take off. So we're gonna be a tiny little, like 4 or 5 sentences.
Yes, and I think that's fine. Yeah, the bottom stuff, that's no. But I do think it should be mentioned somewhere, just because people are, and I think if you said a lot of them are applying for it, they think they can, but they don't need it. Yeah,
So the next page. I don't think we.
A lot of people think we're scary.
What?
A lot of people think a lot of our lives think we're scary.
We're scary?
Yes. They're scared.
that's true.
Yeah, exactly.
I just had a lawyer buy me a plan, a beautiful plan, because I'm so nice and that's why I'm scared.
So this is some things you put together, this is stuff that was summarized
And
and.
I don't remember, I think we took out all the noise code penalty.
Yeah, we talked about taking out the penalty stuff because that's not. And even the complete text of the notice code, I think.
63 guide to connect, oh, that's research. We can leave that one.
Well, we need to update it.
Yeah, so that's.
Yes.
How to address microwave noise complaints.
I think that should be on, but I think it probably needs to be updated. Should we even have, summary of the noise code, complete text of the noise code?
Take it all.
But, I mean, that's a thing, like, not.
It's just too much. I
Um,
don't know what.
that noise control guidelines here that she has listed, it's still dated. I think this is with Jeff Susan, and I think that was actually something that.
So.
I mean, that would be something we could still include as a reference.
I don't know what it says.
We looked at
I
it,
don't remember.
we looked at it on the public press.
So. This says EPA, should it be D? What is, it should be DEP or EPA?
No, it's a D.
I'm looking noise control guidance for nightlife industry, not dated. It says EPA, what is EPA?
Wait, where?
Oh, it's in the middle.
Oh, I'm looking at the one at the top.
The top says DEP.
The top says still in circulation on the DEP website.
So that's probably a mistake, EPA, right?
Down, much be down. Yeah,
So as far as the DEP, so it's another one mentioned last night. I'm working with DEP, we have a new borough commissioner, and I'm working with him at 7th and 9th precincts to have an educational meeting for licensed establishments on the noise rules, noise control, and how to deal with problems. I'm going to do it at the very beginning of June. It's good to send out stuff. So I think they're doing a one pager for that. Maybe we should wait to get something from them. And do that.
I think, under the second section.
Posting.
If it's under commercial music and I think requirements and standards for commercial music mitigation rules, commercial music areas, do we need that stuff even? Well, it's old, it's, and I don't even know if that are. They are. They are perfectly. Yeah, here, the link for this vitamins, see what.
Yeah, you can see that in the what,
Look and see what
what
it is.
site that is.
I can send it to you, I'm gonna on my phone. It's like a list of consultants and.
Oh, yeah, I know what that is now, I don't think we should have that at all. It's like, these are all the acoustical engineers, these are the way we can buy this kind of equipment. I don't think that's not.
Yeah, it's like, you know, it's not helpful. It's kind of, you know,
Yeah, I think that's. Or,
it's 20 years old. Yeah.
okay, so I mean, do we need, let's just look at this, do we need any of, these are all things that are listed currently. Do we need any of this stuff? I mean, maybe the CDP guidance and noise complaint research, how to address something like noise complaints. Maybe that's two
We
things,
need to.
we will update them, but other than that,
And the miscellaneous, which is the joint CD one two one three form from summer 20.
Oh, that's actually good. That's the one we have at the new museum. You remember that?
if this is that. Sure. Let's see, it's.
Doesn't do it for week, right? I wasn't, I don't think I was, I don't think I was, I wasn't doing that, so
I actually organized this.
Pretty.
You know,
you still think it's relevant stuff.
I do, it talks about the kinds of thing, it talks, it's with a lot of common questions. Like, you know, people want to change everything else. And address things like that. I think you should read it, see what you think. And that's one thing I remember because. No.
Open ceiling wall, sound isolation products. Like, I think there's a lot more in depth than.
No, I think we should look at our website, what we want people to focus on.
Yes. And I think this is, I mean, it's some information because they need to figure this out on their own, or not to say on their own, but it's not with a professional, it's not our.
We
It's
don't.
not our place.
I mean, if we start getting into it, like, what are we gonna get in?
Well, that's,
Lease negotiations then?
that's what,
Like,
yeah.
We have to stipulate that they put in their lease next line.
Yeah.
Okay, so, and then,
At the bottom of the page, all those up to date links, that stuff, the paralegal pull together, but I don't think any.
yeah, so this is kind of a summary, you see the numbers on the side here, those numbers correspond to the top of the page.
Oh, it's like an index.
This is kind of like an index you put together. Website, but it's not.
I don't think we have.
Well, it's here, it's this first page. For application something with a 500 goal, I mean, that. This, yeah.
I don't see.
Oh, what we did, the very last page of the packet is the. General
Oh,
policy.
I see. This is something, one of our former. Commissioners, yeah. Just down there, did that. Yeah.
Oh.
So the last page number 3, the SLA committee guideline and forms, I think changed the items.
Yeah, I like that, editing.
And then, you know, again, this is where currently on the website, it does say transfer applications, I think we need to make. Change that language because it is misleading.
Yes.
Yeah, that's key.
Maybe we can say CD3 will likely approve an application that's following the previous stipulations.
Favorably,
Pardon?
some people who favor.
Yeah, like they're.
Applicant.
Yeah, likely approves the problem.
Yeah. I think that's good word, and that would be good for our own guidance and people that are looking to buy a car.
So this actually confused me. It says a new license with a new location and a new license should include the same method as the existing. I don't think we've ever told people that.
No, but this language, some of this is new, this is some of the stuff we went over with her, like. The new liquor, so it used to say a transfer application should include the same method of operation. What's in red is like stuff different. A new liquor license application. In connection with a new location or a new license involving sale of assets from existing liquor should include the same method of operation.
But that's not true.
Yeah, for a new location, that doesn't.
It's not
A new license application in connection with a new location.
Yeah, that's, I see what you're
Should
saying.
include the same method of operation.
Yeah.
But it should be a new liquor license application in connection with a current location,
Right.
right?
So,
Yeah,
New liquor license or sale of assets for a current location.
So how do we define the current location? I think we talked briefly about it before, but that's. The SLA is 6 months from.
no, this is, so that's,
That's
that's the other page, this is the most recent guidance, the SLA lost the lawsuit. Where they were trying to define a date, so this advisory ruling is what they're now operating under. So any, and what they're saying here has been very clear, and. One of our attorneys regularly was the one that this came up with, and they had to push him on. Where it says any lapse in licensing of the premises, licensing will deem that premises not to have been continuously licensed. The applicant can seek it, blah, 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 blah. That statement there is basically saying, if there's any lapse in the relevant, the SLA will keep it in application,
And therefore we will.
and therefore.
We have, there's they create a law.
So prior to this, about a year or so before this, there was a declaratory ruling. And it may have been on the city case, it was a case, I think, in the West Village. And it actually, this declaratory ruling right here came up from the application on Second Avenue.
But it doesn't necessarily mean that the place closes, the place can close and then you keep your license and say.
We're only talking. Unlicensed when it becomes.
When it's expired.
And it expired and then not renewed.
Expires.
Yeah. So, but prior to this, there was a ruling saying it was basically a business closed in 2019, and there were no intervening uses, so the SLA. The SLA made a decision saying that license, that location was still like. There was a lawsuit against them, and the judge and the Supreme Court ruled that's not valid. That there, even without an intervening use, if the license becomes, if the location becomes unlicensed. For any amount of time, even without an intervening use, the SLA has to be unlicensed. So that is,
Just realized we can't see that.
I mean,
No, I've been looking.
I haven't seen it.
See, can't see. it.
No, I can see, I can see, and there's only 4 of them on here right now. So that's why I printed out this ruling, is this is something, there is a section. In the nice weather, outside.
And dancing.
So there is a section that we need to update to address this. Is later on, but I think for this page, just going back to the federal policy, we'd say. A new liquor license application for sale of alcohol for a currently licensed location. Good, and I think that second one, delete that whole, go back to blah, 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 go all the way up to. Should include the same method of operation as the existing business, and incorporate any stipulations with that method of operation.
Not true. You probably have sale of assets, doesn't. Operation.
Well, no, it doesn't have to, but I think this is our guidance, we're basically saying,
What if they're a bar, what if they become a restaurant?
no, I know, but that's something we would consider. But I think the whole point of this is saying that we will, I don't know what language to say, we will. We will view favorably, or we will,
How about they should not have a more impact? Because we don't want it to go from like midnight to 4 a.m., but it's okay to go from 4 a.m. to midnight.
2 a.m., 2 a.m.
Should have limited operation, with.
that is equal or less impact. Existing. But we don't wanna say, because, I mean, what we can't say is that we won't consider it.
No, we were saying we would consider, but you don't want to say it has got the same method because the SLA is never gonna.
No,
support
I know,
that.
we shouldn't say the same, but I think what we're trying to say is. We'll,
I think it's a greater impact. is what it is.
yes, but I think we need, what's our statement that we wanna say what that, why that matters? We're more likely, basically what we wanna say is we're more likely to approve you. If you have a equal or lesser impact, but I don't think we wanna say,
Say particularly set.
but I don't think we wanna say we're more likely to approve you.
Expense stipulation.
What other language
Consider it favorably, so.
is? So we will consider favorable, we would,
I'm gonna be careful with that.
I know, that,
Sounds like.
A yes,
I think, but I don't want it to say that we're, make it sound like we're on.
like, maybe you could just say. Meeting board requests that any.
Community board prefers,
How about prefers?
Yes.
community board prefers that any new license for sale of alcohol or only license. Would. Prefers, and we can maybe find a better word, but I mean, for now, community board prefers any new license for sale of alcohol for a currently licensed location, to include the same method of operation.
Take that out.
Yeah.
Should,
Should require consider the method of operation with similar or less impact on the community.
so actually, so it could use, should include the same method of operation.
That means
Well, but I like what you just said,
would consider a method of operation with similar
Or less.
you could say the same or less impact, because referring to the impact, not to the method of operation.
You shouldn't say, I don't think we can tell people that they have the same.
no, but we're not telling them they have to, we're
Not
saying,
method impact,
But it's the method, impact is fine, I really.
similar with similar or less impact on the community.
Yeah, that you can.
should we then strike the whole thing about incorporating stipulation signed by the original owner? Or-
That's corporate change. I think it's all corporate change, though, it's not.
No, because we're talking about, the way we took it before was, if they were coming with a new license for a new business, we would approve the same method of operation, with different incorporating stipulations, that the same method of operation.
I don't think you should say, first of all, a lot of our stipulations have changed so much.
That's actually a good point.
And it does sound like a corporate change, it would be saying that operation, the exact same stipulation.
However, community would revoke the request to modify the stipulation for, again, the transfer. Modify existing stipulations. Should we just strike that last sentence? The whole, like, instead of trying to incorporate it into what we were saying,
Yeah, it is confusing. I don't think I think it's before it now,
Yeah, said everything.
yeah.
Yeah. It's unnecessary, which I'm sure how you added it at first.
Right,
Yeah,
because we're not
exactly.
focusing on the method of operation so
right.
much, we're focusing on the impact for the community.
So, yeah. With.
So do we think? And I know when we discussed this, Susan, with Amber, I know we struggled with something, but
Yeah, what does that mean? Be applied,
no, we struggled, I mean, that,
so that's definitely.
yeah, we took that out,
Because it's me.
like, just as it would be.
How do we do that? You know, it says we will deny them unless they establish approval would be in the public interest. It's simply not true, because a lot of what we approve is based on what we know is going to be approved by the SLA and we want investigations. And the SLA doesn't even pretend to approve. For instance, I don't know.
So I mean, it does feel like this though, we have to say it, we have to say something about it, but what, I guess, what do we say?
How do you do that? We're no, in our students. Don't like that. They'll say we improve the tax base. Which isn't even a legal reason, but
For having a unique menu.
but they're never alone.
There's nothing here about the 1993 exemption. If
Well,
it's
it's
like,
under the five, if it's.
That says it on the SLA, the 5 description, and this is more just like the guidance around the 5.
What does the SLA application say? They can make your case. Like, I know it's weird, but it seems like you should at least look at something. Here's you for filling out. You should be aware for your application, you're going to be.
That's a good point, yeah, I'll be warning them that it's gonna take long, but they're gonna have to go to a special hearing.
How about something like, please state the public benefit that you will be submitting to them. Is there, they are required to submit something? They have a house.
At least we'll know what it is.
Anything else you want to?
It was the one thing we couldn't. Oh, actually, it is. No, it is. If we go back to the first page, number 5. Where it says under the first bullet point, where it says application subject to the 500-foot rule, full on-premise liquor license application for location that had never been licensed in saturated areas or generally not. That language is what's on this state, that needs to be previously licensed
Right, because of the new.
because of this declaratory ruling, it can't be never. Because never means a totally unlicensed location that's never been licensed. Saying based on this ruling. Previously licensed means is currently licensed and it's being essentially a. Not a transfer, but as we just discussed, but it should be, so I think that needs to be just to match up with the state line, if it said a never, it should be previously licensed.
Locations that have previously been licensed in saturated area, generally.
It's probably sort of fun.
They're previously.
All terms of like some applications for locations. That are. Yes, so
Unlicensed.
it said, yes, you're right, it should be that are. Previously unlicensed, that
Currently unlicensed.
because
Or it's
previously,
are currently unlicensed.
Currently,
that makes it not match up with the.
Everything was previously.
Everything is pretty exact. I was familiar previously like stuff, but yeah. So for premise liquor license for applications in locations that are currently unlicensed in saturated areas, generally not. But we also need to, and this is something we can discuss at the next meeting, but we need to figure out. Because as I said, at our last meeting.
There's a big disconnect from going to administrative approval with both liquor.
Yeah. So we have to, figure out how we want to handle that. Because if we are gonna put full liquor in. For the administrative approval, then that is,
We gotta make it.
well,
No, absolutely, it's a good thing, but I don't think it's gonna be so. I don't know.
Who needs to support it?
Sorry?
We have to put that,
the full board.
I don't think the full board is going to support it because I don't think many in the community. I think it's almost like an emotional thing, it's like full liquor bans, like all the traditionalists and no one drinks.
I mean, what does the board here think about that?
Well, that's what I was saying, I feel like we could wait and discuss that. Next meeting, as more of an in-depth of a revision, tonight, we need to look at what we have currently, to think about. One thing though, I do wanna mention or bring up, I don't know, did anyone see the New York Times article I sent around to you today?
Looked at something for it,
Yeah.
I agree.
I sent it to the, yeah. It was-
New York City becoming this.
But-
They're pointing, they're pointing to the community boards, but I really think it's the free market that's dictated.
Well, I agree,
I think it's the free market,
but
I see it every night.
But one thing that I've heard, and Megan and Steven, you can chime in, but I've heard from several bar owners that are saying, they said, you approved another bar over here. Every time you're taking away customers, I've noticed a change. So we can feel as bar owners, like if we're approving, if we're approving in an unlicensed location, 2 doors down from your space, and we open a new bar. But we approve a new bar. Is that a good thing or bad thing?
When, like another 4 AM license.
Yeah.
I think it's helpful for everybody.
You think it's helpful? Because I've heard that from people too, but I've heard other.
Look at the waiting lines. There's plenty of business, say lines around the block.
It depends, it's like, but like, you have a lot of places, people wanna go to,
A growing problem.
they can hop around from one bar to the
They go out
next.
3 to 4.
Yeah, bar hop.
Like,
But in our area, we already have enough, we already have those 3 and 4 bars. Is there a limit where it's only so many customers, and by opening another bar, we're taking away customers from existing businesses?
if you really think about it, yeah, I think you're right.
That's
but-
what I've heard from a few bar, I've heard what you just said, that it does help. But I heard from other bar owners, if that bar opened down the street, my business would drop 15 to 20%.
I don't think it's true because it's not, it's local. It's people coming in.
But there's still so many people.
It really depends.
Look at it.
And those people coming in are coming in on the weekends.
That's true.
And it's the weekends.
I wouldn't want to bar 2 streets down the tunnel. That'll hurt.
Say that again.
Bridge and tunnel.
Well, your bar is more local than a lot of bars, aren't they?
Most people, transport, but like they all live around.
That's what I mean.
Yeah.
I feel like yours is more local as opposed to somebody in this.
There's not,
It's flowing in. and
Sure.
going through.
No, I don't do, I prefer not. I prefer. To that, like lower inside. Sorry, no.
Well, not people lower the sides.
But so I think this is one issue that, again, I don't want to decide something, but I wanted to bring it up so that we can think about this. How do we want to start addressing when we're getting an application in a completely unlicensed location?
The deal is what's the SLA gonna do? I hate the fact that that's.
No, I know.
That's true. What's the SLA gonna do? And they basically said they think everyone should be given an opportunity.
But giving an opportunity with what stipulations and what. I think
I
that,
do believe in stipulation.
that's the other thing. Should we, should our guidelines be that in an emergency location, we won't. I can't say, but other community boards are taking stands where they're not approving it.
And what is this?
I don't know, have they been challenged?
I don't know if people are, I know it's true, some board, let's say, no one can have more than 2 AM. But I don't know if people are fluid or whether they're being challenged, whether the SLA is,
That's a good
going
question.
along with it, I don't know.
I think CB1, and Megan, do you know CB1 now saying no for everyone? Yeah.
It was,
Yeah, why?
I believe in South Side, it was impossible to get, it was, we eventually got approved for 4 and then on some days, for Australian sports, or sports. Yeah. So, but it's taken a while to approve, but it was, I showed up with easily 200 plus signatures from that area and almost 15 speakers. And the chair looked at me for those 4 years, what's happening? And did it listen to and then that obviously sort of right, but I found out.
I don't think we should go down that road.
No, I'm not saying we should go down that road either, but
And we're gonna get here.
The SLA with the board approval. That's it, and
We-
should, I'm just saying.
Yeah, we had done that originally, because before I am looking for like a year and a half ago. So originally, they approved us, for like 2 AM on weekends, but they wanted us to close at 10 PM on Sunday nights. And I was like, we can't do that, like, if there is a 12 on the rest of the 12 on, we have to. It's gonna go 10 PM on Sunday nights. Because she said it's the warden and she stopped herself because she thought that was inappropriate. So, we wouldn't sign the stipulation, we had to take the other, almost.
so. My point is, and I don't think we should do any kind of ultimatum, you were saying, no 4AM licenses, no anything. But I think what we need to do is carefully think about under what situations we would approve a 4AM. Whether it's geographical, I think sale of assets is one thing, I think we all agree, if it's a 4AM license, fine. I don't think anyone has a problem with that.
Existing
It's an
4AM
existing 4AM
without
license,
problems.
yeah,
What if they have 2 extinguished, what if it's the 12, let's run through real life scenarios, what if it's a 1 AM license? It lasts for. Nobody's approving it.
Well, one of the problems is, it's very easy to go out and get signatures, because particularly certain areas, if you look at the maps, our demographics, certain areas, particularly in these villages, are younger, the people that are actually moving here because that's what they want to do. You're saying no one's opposed to that. Probably it's very likely, Flora hasn't organized that, they don't know about it.
No, I think that to me when they're.
But no, I'm not saying that's a problem. No, I'm saying this is a new one that's coming in, where I don't know about. Right, not an existing, if there's an existing problem, you know it. I'm
Yeah.
talking about a new license.
The other nice thing about having them heard of committee, it gives them residents an opportunity.
But we're talking about no one's opposing, it's like a 4 AM, no one's opposing.
or
And
you
there
can
are-
say 2 again.
Yeah,
There are neighborhoods where no one is gonna, no one knows.
Who's gonna have a say.
That doesn't mean that it's not bothering people, and if you look at, the 311 complaints in that area, there may be a lot of 311 complaints.
Because
Sorry, I had a couple thoughts, to your point, you want to meet with people operating, maybe we could stipulate a suggestion. Your birthday. like post.
So
Yeah,
we used to, we used to
No.
require,
No, it's not.
no, it's not, but we used to, right?
So the reason it's not required. So this is a whole long thing. First of all, it used to people, we used to have people call the office. And we were supposed to tell them who to reach out to. Some areas don't have anyone to reach out to. Then it became, first of all, it took way too much time in the office. Then it became a thing, well, you didn't tell me, it became the office's fault if someone was left out. So what we do now, everything's on the website for groups that have decided self-elected to be on the website. So our letter says, please see our website for a community group. A lot of community groups decide not to go on there.
Most
So,
people do, most applicants do reach out.
Yes.
I didn't mean required, but you suggest.
we suggested, but the other part of that is we post the questionnaires with applicants' contact information. If a resident wants to speak to the operator, all they gotta do is call up or email.
Go downstairs, knock on the door.
It's a two-way deal. No, it's respectful.
Before they're there, right? Like.
Sorry.
And the applicants just coming in and they do like on the front, on the
They're
front.
required to
There's
present
information, and so. There's contact information, yeah.
So that's, we used to make more, but now it's not, it's suggested and that's it, they
That
don't.
works very well, most
But
people will do. that.
Here's the other thing that this is my personal opinion. I don't know what we should do about this, I don't think we should eliminate them, but putting so much stock in the petitions, I think can. I don't, it's not misleading, but I think sometimes like. You know, you can take it to a school, and you can get all the parents to sign it.
Yeah.
And they might all live in the area, so they are all within 200 feet, but. Or 2 blocks, I guess is what we say, 2 blocks.
I don't know, I love the petitions because to me, it's like a massive for to come up, and it's also, it forces you to have conversations.
You're very.
It's good to go, it's
But I
really
think-
notifying.
But I think my point is, and I'm not saying that's why I'm saying, not that we eliminate them, but, and we've had several situations in the last year where people come in and said, so my signature's on there and I didn't sign that. And
They
I,
have mailboxes.
I was told by a former applicant,
Wow.
I was told by a former applicant, you know, when we came 3 years ago, he said. That exact thing, he said, we looked at mailboxes for the buildings around us and wrote them down. I'll tell you who said it. I was told that by an applicant, and they have the problem, don't know, like, but either way, he said, you know, I have to tell you, we did that. And I think that's more, and I've heard that there are some lawyers that advise people to do that. So,
Wow.
That's.
I never thought of that, and now I am.
not advised, I'm saying not advised, but maybe his suggestion. So that's why I'm saying, I don't know how much stock we should put in the
I've been out there for hours in the corner.
and I, yeah.
But I send my wife and my brother's fiance out.
And the other thing, and here's, so where I'm going with this is, right now, it's still, if they don't submit their petition signature, we'll say, you know, your application is complete, you need to come back. We wanted, should we consider still requiring them, and we will review them, we're not gonna make it a requirement that if they don't have them, then we'll just say, well, you didn't do any petition, so that's a lack of public outreach and.
I think we should, so I think you're saying just almost do what you require and then the others not stop it, put in. I think getting them, as Megan says, of course, is going to talk to the neighbors, meet their neighbors. It's a method of notification, is probably the best method of
And
notification.
if they choose to cheat during that process, you know.
Yeah.
But then, right, mistake, and we heard the full board say, I've never seen someone with 250 signatures, and the SLA has actually referred to applications that they had this many signatures. How do we vet, you know, and that's the thing, we don't, so we're putting stock in them in that sense. So, this is my question, I'm not sure.
Well, if it's so overwhelming, I doubt they're cheating to that extent, you know, like, so I think you should put it actually needs in the work. We've always put a lot of we've always found that like very important. And we've done significant, part of the community. And I think it's great for the neighbors, and I think that shows that we really made an effort, so I think you should take stock of somebody's that have like overwhelming support.
You know, if someone comes in with a lot of signatures and building above the bar, we would take stock to that, because these are the people that are really.
And you would be right about that.
And if they come back and complain later, say, hey, we from there.
Yeah, maybe
I
it's something
stopped
going.
for- I
Oh my God, I bet you'll need to do
I
that.
would or testified for POCO to get their sidewalks.
So,
I will fully admit that. And, you know, here, look what happened.
well, I mean, so we can rent them 2 blocks and you're not gonna get 500 or 200 generals across 2 blocks. Because we only learn from people who are.
They do.
I like the language that we have. I think we have some language just like within and the people in the building or correct adjacent.
It was fine, we can leave it as it is, and, you know, it's just, I go back and forth, because I agree with you, that I think there is an importance to them, at the same point. You know, I know sometimes where people have been on it, and there's been people that have come to meetings and said, my signature was there, and I never signed it. So like,
That's a very.
Here's the
telling
thing.
test.
Here's what I'm looking for with the signatures is, do you have like a ton, like you really put in a ton of effort? And that means you have almost none, and that means like you couldn't have thought. That's something to do. And then like the in between, and then the third one is, do you have people from the building? Like, did you make an effort to like knock on doors, people coming in and talk to them and tell them that you want to have fully come in? So, and then, but like, anything in between, you're right, I'm not really.
like many times, like, you know, we've had another situation on Lower Avenue, that, you know, there was an issue and they were all, you know, they didn't have like 75% in the building, but they were all people that, you know, they're relatives that have moved in and out, so.
I know, but you can't nitpick to that extent, you know, I mean, there's still a community,
Yeah.
there's part of the community. And if that running will focus on renting to that age couple students, probably be replaced with another 25 so it probably doesn't matter.
Should that have more weight than the people that, you know, live in the neighboring building for 25 years? And I'm just that.
But, well, I think the issue there is, generally those other people who are disturbed will also, and I think that makes a difference. If you have people saying, you know, I can't sleep because of this place. Now that has to balance out all the kids that live in the building when I go downstairs.
And I'll put that as, it's very interesting fact. But I don't think there's anything wrong. But one thing I waited to, there would be a little more, I think, paid at. The people who made the interpretation. And it isn't, not necessarily this committee and this language, but it has some.
Well, I will. I kind of think how to say it. Sometimes, and you and I know what we're talking about, sometimes it could be a block full of people opposing something. But I feel the need to post anything out there on the block or near the block or corner. And I don't think it's, I don't think all of the people for either reasons.
Still, it's a significant bunch of people one way. The significant bunch of people. You know. For this committee. I just think.
They weren't even solicited,
As one.
But there's not really, that's sometimes if there's really limited business.
Back to the 4 a.m. thing, I mean, my take on 4 a.m.s are always, I think there's a place for them, for some, 4 a.m.s in the neighborhood, I think it. In some places, especially like clubs or music or things like that, they could really add to the culture of the city. Um, that's part of New York City, like being able to like dance all night and, do those fun things. I also think that when you allow citizens to open the 4 o'clock in the morning, and let people out versus emptying the place at 2 o'clock in the morning and 150 people in your restaurant or bar at once. That said, have every place open before 4 in the morning, so what are the parameters?
That's what I was discussing earlier, is we need to figure out. Again, not a black and white, if this will prove or not, we need to figure out the things we're gonna look at, is what I'm down for a license. Do we need to come up with our own guideline where like there's 5 4 licenses within some, and that's an example, but I don't know, like. Because I agree with him, I don't think everything, I think there is definitely a place for 4 licenses, but I don't think everything should be.
That doesn't,
Yeah.
unless it's
Yes.
existing, unless it's existing.
Yes.
I should not,
I think every. That's it.
but that's a big deal, that's a.
Yeah. Yeah, I think that's something that I think everyone would agree on.
Yeah.
Residential
What,
side.
how late should we consider them?
On side streets,
Yeah. So we're talking like, first, second, third streets.
I mean, I guess it depends on, I'm even hesitant to approve. Like, I guess it would depend on whatever it was there before.
Yeah.
And I would be hesitant to approve new licenses on side streets.
And that's something we kind of, we have, we can't say that.
Yeah.
Okay.
I'm gonna say Third Street between A and B for years. There was horrendous for the funds there and find something.
That like Cherry Tavern.
No, Third Street, Third between A and B.
You're talking.
that was,
no, house.
The Malice Palace, came to Tyler, came to
Yeah.
Tyler.
Yeah, we finally got rid of them, and I went, need to.
So I think, that's something, again, not really making changes tonight, but something to think about for the next meeting, like, if we are gonna make some guidelines around it.
In regards to the New York Times article, like, I just wanna have each other. If they're effectively like saying, oh, or,
Well,
but, I really think. I'll tell you this, it's like, and this is kind of mostly my opinion, like, 4 a.m. is not the same as 4 a.m. before the pandemic. It's just like. My thought is like one of the more night, like these thoughts. We're done by, the last year, we're done by 2:30. Like, it's very rarely, very rarely until 3 o'clock.
Kids are
Very
making
rare.
so much less.
Yeah.
What if you're not gonna move in and work out?
Come on.
Like,
So,
they have work-life balance.
Avenue A where I live, it doesn't start till 11:30.
It's true, yeah.
and it still goes till 4, like they're on the street at 4.
Yeah,
They're screaming on the street.
I see,
Screaming.
I see that, I know. And it's, I do my
You
best.
haven't felt that way, okay.
But, I'm thinking, we start. We're either approving 2 a.m. licenses or 4 a.m. license, we haven't really gotten. I think we, should table it, maybe like a 2:30 license. I believe CB2 does 2:30s.
Oh. That helpful? That would actually have out.
I think there's a big difference between 2 and 2:30. I don't think there's a big difference between 2:30 and 4. That's just my opinion.
so, there was a couple different opinions in that article, but some people in that article were saying the same thing.
I agree.
So Ariel's Didn't recall it, and she's anointed to finishing, now it's just no longer government, just action. So
Yeah,
I'm gonna say something about CB2. CB2, other than their McDougal, they will tell you they don't have that problems. The people that drink there, other than that, are
Older,
yes, they're not people on the street screaming and yelling.
they're like late 20s. Yeah.
so that's something we just, I mean, you make a very good point, and maybe it's something, again, we're not gonna pass a black and white resolution, we're not gonna do this, but if it exists at 4 AM, yes. You know, we're gonna seriously consider, we'll figure out a wording that like, basically not approved 4 AM, unlicensed locations or something that is not 4 AM on the side street. And, you know, any new applications for 4 AM will have to be seriously considered regarding whatever the stipulations, or not stipulations, whatever qualifications. we want to put in.
Maybe tell them where they should be, because one of the things you want to do is kind of drive people if you want to 4 AM. You want the 4 AMs on Bowery, you know.
But we
like
have to
that.
be careful saying that, because then there's people that live over there and are gonna
But
say,
they're commercial areas, I mean, let's face it, you could live in a commercial area, there's a big difference between living on a Bowery and living.
for example, state for another, was murdered on Christie, all those bars around in the valley, they're saying this is adding to this area.
It should have nothing to do with anybody. I mean,
I'm just saying what we
seriously.
hear.
But it's not true, it's not anything to take into consideration. A mentally ill person who had been violent in this way, he was, you know, at least knew who he was not in any of those bars, he wasn't a bar.
I'm just saying, people that live there, when you say it's a commercial area, it doesn't matter, I'm not saying we didn't say it doesn't matter. But when you say it's a commercial area, we can add in. And then.
But you've gotta have it somewhere, right? You can't tell people you can't do anything
Well,
anywhere.
and I'm not saying, but I'm just saying we should be careful putting in a stipulation, that we wanna steer people toward
If
that.
if you want to influence the, and there are a number of lawyers who will call up and say, what do you think about this? What do you think about that? And they will tell, applicant, if we say it's not gonna be looked at well here, they'll tell them to steer someplace else. So one of the things you wanna do is be clear and be consistent, so that you
Yeah, I
let
agree.
people know
See, it's-
before they spend.
Like, Essex Street, Essex between Houston and Lincoln, that's commercial, we want to keep adding more 4 AM licenses there.
Well, adding more is different than, I mean, there's a lot of for it already. So, well, that's another thing you could say is you prefer that before you go into the business system.
And that's fine, I think we're all agreeing on that, if it's existing 4 AM, I don't think, unless it's a problem location with like. For, you know, many good reasons. Yeah, I think if it's an existing 4 AM, I think we're all in agreement that there's very little issue with another 4 AM going in there.
There's a lot of for it.
I know, but that's what I'm saying, that's a commercial, there's very little residential in that stretch. But there's still a bunch of places that are 4 AM, if we want to steer people to just commercial area. I just think we need to be careful.
Maria?
I think it's just fine, I mean, it's got plenty of. So wide lanes, it's got plenty of school.
Some people there. You know,
Yeah,
I mean,
it's easily accessible, yeah.
if they're not bothering people,
But, I mean, like Sun Valley, 133,
if they can be paid. If they- And there's a big difference between, you know, someplace, most places behave well, the problem we have is people out on the sidewalk. when
well,
most
but that's
of
what
us-
I mean, we're adding more people to the sidewalk, and that's what we would do. I don't know, that's the question.
Well, in that particular location, there's some lots, but, yeah, I mean, I could see, you know, if you want more programs of leverage, why not?
Yeah, well, that's, what are your options, you know, if they're gonna have some for AM. Where do you prefer to have? You don't have the option, you always say you don't.
I'm just hesitant to put any of this in writing.
Well, that's,
Like,
I agree.
it's not giving you guidance.
I know, but we do need, that's why we have to be careful what we put in right. We do want to give guidance, but it's a very fine line between giving guidance and, like you said, putting this in writing, that's why.
If you're not putting it in writing, you're not giving it.
I know, so that's why we need to be very careful how to phrase this, like that's why I'm saying, even though I don't disagree with you that. Commercial, but if we put that in writing, there are people who are gonna go nuts,
Well, I'm gonna say you can't make everybody happy all the time.
I know,
And you guys are appointed to look at the community as. And look at the problems, and so you're addressing problems, and how do you best address and mitigate problems?
I mean, you could say something like, community board, I've been listening, so usually steers clear of 4 AM licenses, or, it's rare that we approve them, things that I consider is, you know, number of other 4 AM licenses, such as Avenue, like you could kind of say, like, different things that we
Yes.
consider, and so then when they, without necessarily meaning,
I agree with that.
I mean,
dangerous situation.
well, and I think also,
It's broad enough.
congestion.
Yeah,
Nothing that's gonna.
vehicular congestion, and then, you know, when somebody's trying to get something on, you know, Avenue B and.
Well, we already do mention. Having A, B, and C. In the first and following, right?
Yeah.
And we mentioned out of A, B, and C, and we mentioned the area, we basically Health Square, Lower East Side, out of Essex.
So we don't want to do that.
So we're already.
We're already covering that part.
We consider that it's, in a wrong location, if it's an oversaturated area, vehicular traffic, safety concerns.
Yeah.
Neighbors complaints or whatever, you could say whatever, but like, you could start by saying, look, this isn't something.
4 AM, sorry, very approved.
Yeah, yeah.
So we used to have good guidelines, but the committee was totally inconsistent, so therefore the lawyers all knew that they could come in.
Yeah.
And that's what I would like to get back to, is having
But
some consistent guidelines that we.
you need to know that you're consistent, and it's a waste of time. But it also has to be clear. It has to be clear, you can go here, you can't. And it's never 100%, you know, you're not saying we won't approve anything, or we don't always approve, but you gotta, you know, where they can be.
Yeah, so I think this is a good stopping point.
Yeah.
We kind of went through a lot, we have something, I will. Mock up, and what I think, what maybe this time too, like all of this stuff is gonna flow back to the website. We have a lot of cleanup, we need to do on the website, there's a lot of duplicate things and we wanna kind of consolidate all the SLA stuff. Basically one page with maybe a link to a couple other things, but right now it's in about three or more places. So if we, at least, I don't know if we probably don't have that. Updated by.
No.
So that, but.
I'm not updating the website until you got.
No, but at least, but at least have, you know, a better idea of, you know, what we want that one page to look like and what we do based on some of the provision. Once we have this, I think we can have a deeper conversation about some of the stuff we touched on, such as what kind of guidance we must provide for it. And those sorts of things.
So we can update some of those things, we can just update.
Yes,
Right.
And some of the things, we have a few things that should investigate.
but now here's my question. In terms of. What do we need? You know, if we're so for this, for example, on this, where we're changing, you know, Avenue A and St. Mark's, like we're changing that to Avenues A, B, and C.
That you need to, so that should be kept a track, change this, that's a policy.
That's where.
that has to go. So some things are not policy things, like just getting rid of stuff because they're not ours, they're.
So we don't have to, that doesn't have to go to the pool,
No, any policy change, we should keep as a.
And a track change.
And that to go to.
and not go to the pool. But if we're just deleting unnecessary stuff or outdated stuff,
Yeah.
so really. Well, if we're deleting stuff in this policy, but I
If
think.
it's not our policy.
We're deleting the other stuff like. Best practices and stuff, that really are.
Yeah, or deleting DEP stuff, that's not policy. we're deleting SLAs.
And like deleting the letter that.
It never came before the board,
Yeah.
nobody knows it's on the website.
Yeah. Okay. Does anyone else have any questions before we adjourn or any other
You
thoughts?
guys need to take.
I don't know about the 4 AM thing, should we talk to Ariel about this?
No,
What's she
Okay.
think, what's she thinking about?
after she crashes community courts,
Well, I mean,
what is she, what does she have to do? She had a bar that had more
Yes.
311 complaints than any other bar in the whole city. And she was
She was on this committee.
She was
yeah,
on-
she was, and she caused a lot of problems,
How
because
long-
she gave all information.
How long was this committee for?
I don't know. My job.
She had a bar at
The
16,
article said saying it, yeah.
she had a bar at 16 First Avenue, and you can Google this, it had more complaints than any other place in the whole city.
Okay, well then that's that thought. Any other thoughts? before we adjourn?
And what is her authority? She works for markets. What?
They brought it up.
They didn't bring up, asking her.
Oh, before we adjourn, motion to adjourn.
Stop.
Email,
Yes.
Michael,
Here's,
Jeff, DMO, Megan.
and we're gonna ask
Meeting
someone
adjourned.
that works for Frank. And we went out and-
Then in front of DMO.
That was a good meeting, well done. Thanks.
It was like the most.
No, no, it was good.
Next.